Nullification dates back to 1798, when James Madison and Thomas Jefferson drafted the Virginia and Kentucky resolutions, respectively. There we read that the states, which created the federal government in the first place, by the very logic of what they had done, must possess some kind of defense mechanism should their creation break free of the restraints they had imposed on it. Jefferson himself introduced the word nullification into the American political lexicon, by which he meant the indispensable power of a state to refuse to allow an unconstitutional federal law to be enforced within its borders. Today, political decentralization is gathering steam in all parts of the country for all sorts of reasons. The principles of '98, as these decentralist ideas came to be known, were in fact resorted to more often by northern states than by southern, and from 1798 through the second half of the 19th century were used in support of free speech and free trade, and against the fugitive slave laws, unconstitutional searches and seizures, and the prospect of military conscription, among other examples. And nullification was employed not in support of slavery, but against it, as when northern states did everything in their power to obstruct the enforcement of the fugitive slave laws, with the Supreme Court of Wisconsin going so far as to declare the Fugitive Slave Act of 1850 unconstitutional and void. Nullification violates the Constitution's supremacy clause, unquote. This may be the most foolish, ill-informed argument against nullification of all. It is the reply we often hear from law school graduates and professors who are taught only the nationalist version of American history and constitutionalism. Thus we read in a recent AP article, quote, "The efforts are completely unconstitutional in the eyes of most legal scholars because the U.S. Constitution deems federal laws the supreme law of the land," unquote. What the Supremacy Clause actually says is, quote, "This Constitution and the laws of the United States which shall be made in pursuance thereof, ellipsis, shall be the supreme law of the land," unquote. In other words, the standard law school response deletes the most significant words of the whole clause. Thomas Jefferson was not unaware of and did not deny the Supremacy Clause. His point was that only the Constitution and laws which shall be made in pursuance thereof shall be the supreme law of the land. Citing the Supremacy Clause merely begs the question. A nullifying state maintains that a given law is not in pursuance thereof, and therefore that the Supremacy Clause does not apply in the first place. Such critics are expecting us to believe that the states would have ratified a constitution with a Supremacy Clause that said, in effect, "This Constitution and the laws of the United States which shall be made in pursuance thereof, plus any old laws we may choose to pass, whether constitutional or not, shall be the supreme law of the land." Alexander Hamilton himself explained at New York's ratifying convention that while on the one hand, quote, "acts of the United States will be absolutely obligatory as to all the proper objects and powers of the general government," unquote, at the same time, quote, "the laws of Congress are restricted to a certain sphere, and when they depart from this sphere, they are no longer supreme or binding," unquote. In Federalist number 33, Hamilton noted that the clause, quote, "expressly confines this supremacy to laws made pursuant to the Constitution," unquote. At North Carolina's ratifying convention, James Iredell told the delegates that when, quote, "Congress passes a law consistent with the Constitution, it is to be binding on the people. If Congress, under pretense of executing one power, should in fact usurp another, they will violate the Constitution," unquote. In December 1787, Roger Sherman observed that an, quote, "excellency of the Constitution," unquote, was that, quote, "when the government of the United States acts within its proper bounds, it will be the interest of the legislatures of the particular states to support it. But when it leaps over those bounds and interferes with the rights of the state governments, they will be powerful enough to check it," unquote. Quote, "Nullification is unconstitutional. It nowhere appears in the Constitution," unquote. This is an odd complaint, coming as it usually does from those who in any other circumstance do not seem especially concerned to find express constitutional sanction for particular government activities. The mere fact that a state's reserved right to obstruct the enforcement of an unconstitutional law is not expressly stated in the Constitution does not mean the right does not exist. The Constitution is supposed to establish a federal government of enumerated powers, with the remainder reserved to the states or the people. Essentially nothing the states do is authorized in the federal Constitution, since enumerating the states' powers is not the purpose of and is alien to the structure of that document. James Madison urged that the true meaning of the Constitution was to be found in the state ratifying conventions, for it was there that the people, assembled in convention, were instructed with regard to what the new document meant. Jefferson spoke likewise. Should you wish to know the meaning of the Constitution, consult the words of its friends. Federalist supporters of the Constitution at the Virginia Ratifying Convention of 1788 assured Virginians that they would be, quote, exonerated, unquote, should the federal government attempt to impose, quote, any supplementary condition, unquote, upon them. In other words, if it tried to exercise a power over and above the ones the states had delegated to it. Virginians were given this interpretation of the Constitution by members of the 5-man commission that was to draft Virginia's ratification instrument. Patrick Henry, John Taylor, and later Jefferson himself elaborated on these safeguards that Virginians had been assured of at their ratifying convention. Nullification derives from the surely correct compact theory of the Union, to which no full-fledged alternative appears to have been offered until as late as the 1830s. That compact theory, in turn, derives from and implies the following. 1. The states preceded the Union. The Declaration of Independence speaks of, quote, free and independent states, unquote, that, quote, have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other acts and things which independent states may of right do, unquote. The British acknowledged the independence not of a single blob, but of a group of states which they proceeded to list one by one. Article 2 of the Articles of Confederation says the states, quote, retain their sovereignty, freedom, and independence, unquote. They must have enjoyed that sovereignty in the first place in order for them to retain it in 1781 when the Articles were officially adopted. The ratification of the Constitution was accomplished not by a single national vote, but by the individual ratifications of the various states, each assembled in convention. 2. In the American system, no government is sovereign, not the federal government and not the states. The peoples of the states are the sovereigns. It is they who apportion powers between themselves, their state governments, and the federal government. In doing so, they are not impairing their sovereignty in any way. To the contrary, they are exercising it. 3. Since the peoples of the states are the sovereigns, then when the federal government exercises a power of dubious constitutionality on a matter of great importance, it is they themselves who are the proper disputants, as they review whether their agent was intended to hold such a power. No other arrangement makes sense. No one asks his agent whether the agent has or should have such and such power. In other words, the very nature of sovereignty and of the American system itself is such that the sovereigns must retain the power to restrain the agent they themselves created. James Madison explains this clearly in the famous Virginia Report of 1800. Quote, the resolution of 1798 of the General Assembly of Virginia relates to those great and extraordinary cases in which all the forms of the Constitution may prove ineffectual against infractions dangerous to the essential right of the parties to it. The resolution supposes that dangerous powers not delegated may not only be usurped and executed by the other departments, but that the judicial department also may exercise or sanction dangerous powers beyond the grant of the Constitution. And consequently, that the ultimate right of the parties to the Constitution to judge whether the compact has been dangerously violated must extend to violations by one delegated authority as well as by another, by the judiciary as well as by the executive or the legislature, unquote. It says quite a bit about what people are learning in school, that they are terrified at the prospect that their country might actually be organized the way Americans were originally assured it would be. Local self-government was what the American Revolution was fought over, but we're told this very principle and the defense mechanisms necessary to preserve it are unthinkable. Part of the reason the idea of nullification elicits such a visceral response from establishment opinion is that most people have unthinkingly absorbed the logic of the modern state, whereby a single, irresistible authority issuing infallible commands is the only way society can be organized. Most people do not subject their unstated assumptions to close scrutiny, particularly since the more deeply embedded the assumption, the less are people aware it exists. And it is this modern assumption, dating back to Thomas Hobbes, that, whether they realize it or not, lies at the root of nearly everyone's political thought. Not only is this assumption false, but the modern state to which it gave rise has been the most irresponsible and even lethal institution in history, racking up debts and carrying out atrocities that the decentralized polities that preceded them could scarcely have imagined. Why it should be given the moral benefit of the doubt, to the point that all skeptics are to be viciously denounced, is unclear. If the arguments for nullification make sense, and they do, that is what matters. Reality is what it is. The compact theory from which nullification is derived does describe U.S. history. There is no way to evade that brute fact.